Shell pledged net zero by 2050. A court just called that a legal liability. In 2021, a Dutch court ordered Shell to cut its emissions 45% by 2030. Shell appealed. While that appeal was still active, internal planning documents, later obtained by environmental legal teams, showed Shell had already greenlit expansion drilling projects that, by their own emissions models, made the 45% target mathematically impossible. The appeal was still running. The drills were already moving. For decades, Shell was the oil company that seemed to understand the assignment. They published climate reports. They set net zero targets. They hired sustainability directors and put them in front of cameras. In 2021, their CEO Ben van Beurden stood on a stage and called climate change the defining challenge of our time. The press largely agreed. Shell was framed as the responsible one, the major that was engaging. That framing held for years. It was also, by nearly every internal metric, a performance. Shell's own 2021 internal scenario models projected that continued oil and gas expansion would push their operational emissions above 2019 levels by 2030. Their public target said minus 45%. Their internal trajectory said plus. Both documents existed simultaneously. The May 2021 Dutch court ruling, Milieu Defensie versus Royal Dutch Shell, was the first time in history a private company was ordered by a court to align its business model with the Paris Agreement. Not a government, not a policy body, a company ordered to restructure. Judge Larissa Alwyn's ruling stated Shell's current policies were not concrete and not effective. She did not say Shell had failed to try. She said Shell's efforts were legally insufficient to protect the rights of Dutch citizens from climate harm. That distinction matters. Intent was not the issue. Structure was. Shell's public response called the ruling disappointing, but said they were already on the right path. Van Beurden told reporters Shell was not going to stop investing in oil and gas. Then, 11 months after the ruling, Shell announced it was relocating its headquarters from The Hague to London. The Dutch ruling was jurisdictionally anchored to The Hague. They moved. Shell's headquarters relocation was completed in January 2022, while the appeal against the Dutch emissions ruling was still pending. The timing was not coincidental. Legal analysts noted Shell's new UK domicile complicated the Dutch court's enforcement mechanism. A court orders you to change. You move countries. Meanwhile, internal documents from Shell's own energy transition strategy, portions of which were surfaced during discovery proceedings, showed that Shell's net zero framing was built around what they called carbon intensity reduction, not absolute emissions cuts. Carbon intensity measures emissions per unit of energy produced. If you produce more energy, intensity can fall while total emissions rise. Shell knew this. The distinction was buried in footnotes. Their public communications did not use the word intensity. They used the word emissions. ClientEarth, the environmental law nonprofit leading the most recent wave of litigation, is not a protest organization. They employ over 200 lawyers across 9 countries. They have successfully litigated against governments, banks, and energy majors in courts across Europe and Asia. When ClientEarth announced in 2023 they were suing Shell's board of directors personally, not the company, the individual directors, it was the first lawsuit of its kind anywhere in the world. 13 directors, named individually. The argument, they had a fiduciary duty to manage climate risk. They didn't. That was a breach. Charlie Cray, a governance analyst who reviewed the filings, described it as treating climate denial the same way you'd treat financial negligence. The UK High Court dismissed the ClientEarth case in May 2023, but the dismissal judgment included a line that almost no outlet reported. The court found that Shell's directors did have a duty to manage climate risk. It just concluded ClientEarth lacked standing to enforce it. The duty was confirmed. The enforcement failed. That is not a victory for Shell. That is a loaded chamber. Because now a second wave is building, and it is not coming from nonprofits. In early 2024, 11 municipalities in the Netherlands, including Amsterdam, filed a coordinated climate liability claim against Shell, citing the still active 2021 ruling and Shell's continued expansion activity since. Simultaneously, the city of Honolulu, Hawaii filed suit against Shell and 4 other oil majors under state tort law, arguing Shell's products directly caused the infrastructure damage Honolulu is now paying to repair. These are not symbolic cases. Honolulu's complaint runs 149 pages. It cites Shell's own advertising campaigns from the 1980s, campaigns that used language Shell's internal scientists had already flagged as misleading. Internal scientists, who flagged it. That 1980s detail is not incidental. A 1988 Shell Confidential report, titled The Greenhouse Effect, was obtained and published by The Guardian in 2018. The report accurately predicted global temperature rise, sea level increases, and extreme weather patterns. It named the mechanism clearly: fossil fuel combustion. It was marked internal. It was never published. In the same year that report was written, Shell ran public advertisements calling natural gas a clean alternative. The gap between those two documents is now the center of every major climate fraud case against them. Shell's legal defense has consistently returned to one argument: they followed regulations. Every jurisdiction they operated in, they complied with the law. And technically, that is accurate. But the Honolulu complaint, the Dutch municipal filings, and the original Milieu Defensie case all make the same counter-argument. Compliance with existing law is not a defense when you actively worked to shape those laws to keep the bar low. Shell's lobbying expenditure through industry groups like the American Petroleum Institute exceeded $100 million annually across the 2010s, according to disclosure filings analyzed by InfluenceMap. They helped write the standards. Then they met the standards. Then they called it compliance. In 2023, Shell posted $28.3 billion in net profit, its second highest annual result ever. That same year, Shell quietly reduced its low-carbon investment target, cutting its renewable energy budget and redirecting capital toward new oil and gas licensing. CEO Wael Sawan, who replaced Van Beurden in January 2023, told investors directly, "The energy transition does not mean doing less oil and gas." Analysts applauded the capital discipline. Courts are now calling it evidence. Here is what the escalating litigation is actually arguing, stripped of legal language. Shell had the data in 1988. They ran the opposite campaign publicly. They lobbied to keep regulations beneath their own emissions projections. They rebranded as sustainable while expanding extraction. They moved jurisdictions when a court got close. They made $28 billion the year they cut their green budget. That is not a story about corporate failure. That is a story about a system working exactly as designed. The Dutch appeals court is expected to issue its ruling on the original Milieu Defensie case sometime in 2024. If it upholds the 2021 order, Shell will face a legally binding, court-enforced emissions reduction target in a jurisdiction they no longer technically operate from. Enforcement mechanisms are still being defined. What legal scholars are watching: whether the ruling establishes precedent that other courts, including those in the United States, Australia, and Germany, can cite directly. One ruling. 17 jurisdictions watching. Shell didn't hide the science. They filed it. They didn't ignore the risk. They modeled it. They knew in 1988. They planned around it. They profited through it. The lawsuits aren't uncovering a secret. They're forcing a reckoning with a document Shell wrote themselves. The most dangerous evidence in a climate trial is often the defendant's own words, written before anyone thought they'd be read in court. This is Redacted Chapter. Subscribe so you don't miss the next one.